Welcome back to Pace Immigration, paceimmigration.com, talking with immigration lawyer Michael O'Rourke. Michael, good to see you.
Hey, Sean, how's it going?
It's going okay, but I need you to sort me out a little bit. There's big changes afoot with the E-2 visa. Not many people are talking about it. Again, another issue that's kind of flying under the radar early in 2023. These changes are part of a spending bill for national defense. Talk about how that happens.
Yeah, changes have arrived. They're not just a coming right now.
Right.
The 2023 National Defense Appropriations Act, named after Senator Inhofe, who's retiring from Texas, that is a massive armed forces support and spending bill. But slipped into the bill was a very interesting provision about adding Portugal to the Treaty of Friendship and Navigation that the U.S. has with various countries, and a restriction on the use of E-2 visas and E-2 applications for certain citizenship by investment folks.
Right. Let's get into that. So I don't want to bury the lead too much because the big change is about the E-2 stuff. But I did want to mention Portugal here. Portugal is now designated as an E-treaty country. Portuguese passport holders are now eligible to obtain an E-1 and an E-2 visa. Talk about a little bit of this, Michael.
Sure. So to the Portuguese listening to this, parabéns a Portugal. But okay, there's my bad Portuguese. So you can, if you are a Portuguese citizen and your company is a Portuguese company and it is considered to be a Portuguese company either through its ownership structure, you can qualify for either an E-1, which is a treaty trader visa, which is a creature of the State Department. If more than 50% of your trade, your foreign trade, is with the United States, you can qualify for this E-1 based on your trading relationship that has been in existence and has a sustained regular element to it. You can get that visa for 5-year periods, and that's renewable generally indefinitely as long as the trading relationship still exists. Or you can get an E-2 visa, which is based on a substantial investment in the United States.
Right. So it's a way for Portuguese citizens to establish themselves and to live in the United States through their business acumen, as it were. So that's great for them. But there has been another change, which I think is actually bigger, unless, of course, you're from Portugal. But there's a big change here because we've heard about citizenship by investment through places like Grenada for years. Talk about this big change, because I have a feeling anyone who is thinking about going that route in order to achieve an E-2 visa is going to be surprised.
Yes, so this is a big change. It's a big deal, and we haven't seen much about this. It hasn't been in the news, really. A couple legal scholars have commented on it, but it used to be, prior to December 15th, it used to be that you could purchase citizenship in various countries that already have pre-existing e-visa treaties with the United States. Grenada is a good example because they have a citizenship by investment program where in about 6 months with a nice sum of money, you can purchase a Grenadian passport.
Right.
Grenada has an E-2 treaty, so that means that if you have Grenadian citizenship, you can then make an investment in the United States and leapfrog into the U.S. So, for instance, if your first nationality is, say, Nigerian or Russian or Chinese or whatever, you could use Grenada as a springboard to get into the United States. This has now changed with the NDAA. Now this law, or this provision in this law, now requires that you live 3 years in the country where you have acquired citizenship by financial investment before you will be considered for an e-visa. This really just, it kind of codifies what has been happening recently with e-visa practice in these countries. There was more or less an unwritten or informal rule where, say, Russian citizens getting getting Grenadian citizenship were being denied en masse from e-visa applications. So now this is formalized.
Right. I mean, we would look at it as closing a loophole in a sense, and obviously, I mean, look, the BRIC countries, so-called, so you've got Brazil, Russia, India, China, they do not have e-visa treaty status with the United States. So it was a simple way for them, I'm just paraphrasing what you said, to apply for citizenship by investment in Grenada, get that passport. 6 months later, it's possible to get into the U.S. You have it, though, and this is an interesting point. You have it that, look, just because you got the Grenadian citizenship doesn't mean you were set up for an E-2 visa.
Exactly. So what has been happening over, I would say, the last year is that more and more E-2 visa applications from Grenada and from any other country that has a citizenship by investment program, they were looking at the living patterns, the background of these investors, and if they were just financially invested to get this citizenship in the E-2 country, they were denying the applications.
Right. We should note that it does not apply to existing or previous e-visa holders. So if you're in the United States now from whatever country on an e-visa, this does not apply to you. It's not like you're going to lose it tonight.
Exactly.
Okay, let's take a quick look at something, and we should give a shout out to Dylan Colucci down in the United States. He's a lawyer. He has an interesting blog up, and I was looking at it. He talks about, so the word domiciled is in there, that you have to show that you have been domiciled for 3 consecutive years down in the country that you're applying from. Let's use Grenada as shorthand, so that you were living, well, even now I'm already messing it up because I'm saying living in, but that word domiciled is kind of funny. What do they mean?
Yeah, domiciled is a term of art. It's to show that that is your country of primary residence, that, that's where your property is, that's where your car is registered, that's where you are filing taxes if there's a tax filing system. It is, there are many different considerations to what domicile is, but the shorthand is, do you live there?
Right. I mean, this is all getting back. If we could just keep it simple, I think, at least in my simple head. But they want to know that getting the citizenship wasn't just for the E-2 visa, I think is where they're going with this. There are some diplomatic considerations. That's what I was reading in Colucci's blog about, and you mentioned it when we were off camera, that other countries are like, well, wait a second here. We've got a treaty, and now you're kind of changing things.
Yeah, so most of these e-visas stem from the kind of the generic name of Treaty of Friendship and Commerce and Navigation that the U.S. signs with various countries. And often there are reciprocal rights under these treaties, but this act, or now this law, actually changes treaty rights of citizens of these countries. So I'm not sure if this would stand up to a court challenge, but it seems to be a unilateral change to a treaty and to a treaty benefit. So I'm not sure if this could withstand judicial scrutiny.
Yeah, it'll be interesting to see what happens. There might be some interesting diplomatic discussions over the telephone and in offices in Washington, D.C. We'll keep an eye on that in the days ahead. But alternatives, let's talk. Okay, let's say it stands. Let's say this is the way, well, it is the way it is until they change it. So let's look at some alternatives for people who were like, you know what, I was thinking of the E-2, maybe using country and investment immigration to get the E-2. That appears to be maybe moot. So what can they do?
Yeah, so what they can do, just before, I wanted to touch one more point on diplomatic considerations. So even if it is challenged in the courts, even if this portion of the law is invalidated or enjoined, the State Department does what the State Department wants to do. So it might not approve the e-visa application, even if there isn't a legal basis to do it. There are so many different considerations in these applications that they can always find a pretext to deny. So whether and what type of journey this takes through the courts, it's still, we're looking at the reality that if you're a newly minted Grenadian citizen or a Montenegrin citizen or anywhere where there's an E-treaty, you might not be getting your E-2 visa. So
yeah, that's interesting. I mean, it is worth pointing out that they've just basically put it in writing now to let you
yeah,
know, hey, don't think that the E-2 is going to be an easy avenue for you. So when we talk about alternatives, maybe what we should be saying is these are more the new number one routes to go, as opposed to the investment route.
yeah. So
Mm.
my two biggest alternatives, I think, would either be intercompany transfer. If you have a company somewhere and you decide to set up an affiliate in the US and you have majority ownership and control, you can transfer yourself or other folks in your company to your US office. Of course, there are requirements, both in terms of what kind of jobs can transfer and how long the person has to have been working with the foreign company. But this is often a good alternative for many, many folks.
Okay.
The second alternative is the more expensive route, and that's the EB-5,
Right.
where minimum investment now under EB-5 is 800,000 in depressed areas and 1,050,000 in more urban or more wealthy areas. But if you have that sort of money, EB-5 could be a viable option, and it leads right to a green card. Although a conditional green card, it's still a green card, where the E-2 and E-1 visas were just non-immigrant visas, which would allow you to work in the United States, but didn't provide or do not provide a super clear pathway to permanent residence if that's your goal.
Right. And there was also a kids thing in there, isn't there? If you're in the US on an E-2 visa, and of course you'll correct me when I'm wrong, but if you're in on an E-2 visa, your children reach 21 years of age, some kind of change happens there, no?
Yeah, so they can no longer ride along as your dependents. So they would either have to, say, move on to an F1 status if they're studying, or if they have skills that your e company could employ, then that is sometimes an alternative that we see, where the children then become employees of the e-visa company. So that's always a possibility, but they can't stay as dependents on yours once they
Right.
age out.
Okay. So we're looking at intracorporate transferee and EB-5 as two pathways that they could go. And if you're interested in those, contact Michael O'Rourke at mo'rourke@pacelawfirm.com. Michael, we'll keep an eye on this one and see how it plays out in the halls of justice and otherwise down in Washington, D.C., and over the telephone lines from various countries. And we'll see what happens coming up on 2024.
Yeah, it'll be interesting to see what happens, but even if it does become the subject of an injunction, I still think E-2 visa, especially from citizenship by investment countries, is not the best pathway right now.
Right. The writing is on the wall. Okay. Thank you, Michael. We'll talk to you soon.
Sounds great, Sean. Take care.
Bye-bye.
Bye-bye.